In the context of rule of law, we would like to discuss the very provision in the Constitution regarding Article 21, which provides right to life and personal liberty, and there itself it provided that no person shall be deprived of his life or personal liberty except according to the procedure established by law. So, this very procedure established by law, which is always in contravention or in contradiction to the very principle of rule of law. So, in the leading case, People's Union for Democratic Rights versus Union of India in 1982, the Supreme Court expressed that the state is bound to assure the observance of the labor legislation enacted for securing the workman a life of human dignity, and in action on the part of state in implementation of such legislation would amount to denial of the right to live with human dignity as enshrined in the very Article 21 of the Constitution. So, in the leading case, Bandhu Mukti Morcha versus Union of India in 1984, Supreme Court expressed that right to life should be taken to mean right to live with human dignity free from exploitation. And in another important leading case, that is relating to Olga Tellis Bombay Municipal Corporation in 1986, Supreme Court made it clear that the expression right to life includes the right of livelihood also, but it may be curtailed or curbed by following the just and fair procedure established by law. And in another most important leading case, and that is State of Maharashtra versus Sripati Dubal in 1986, the Bombay High Court has held that right to life as in Article 21 includes right to die as well. The court had struck down Section 309 of Indian Penal Code, which provides punishment for the attempt to commit suicide as being violative of Article 21. And in the last most important leading case, that is Rathinam and Bhusan Pattnayak versus Union of India in 1984, the Supreme Court also held that Section 309 of the Indian Penal Code, which provides punishment for the attempt to commit suicide, is violative of Article 21. So, the very question is that what exactly personal liberty consists, and right to personal liberty has also been given very wide construction in Maneka Gandhi versus Union of India in 1978, where the Supreme Court held that the expression personal liberty as enshrined in Article 21 is of widest amplitude, and this very fundamental right consists also the right to travel. So also it also consists many such rights like to travel abroad and to speedy trial, as it was decided in the very leading case Husainer Khatun versus the state of Bihar in 1979. Sole prisoner remains a human being, notwithstanding his imprisonment, and is entitled to the right to life and personal liberty as guaranteed under Article 21. So, he has right to life and personal liberty, and it cannot be taken or curtailed except according to reasonable, fair, and just procedure established by law, as it was decided in the very important leading case Sunil Batra versus Delhi administration in 1978. So, right to free legal aid is also implicit in the very guarantee provided under Article 21, as it was decided also in the very important leading case Husainer Khatun versus State of Bihar in 1979. So, from these all leading cases, we could conclude a very idea that the very right to life and personal liberty is an integral part of rule of law as enshrined in the Constitution of India. But how it could be curtailed and restrained, and it could be curtailed or restrained by a just and fair procedure, and that must be established by law. So that very procedure must be very reasonable. It must not be arbitrary. And in the same way, when we discuss regarding those fair and reasonable and just procedure, it means exactly guaranteeing and providing security and safety from the very arbitrary actions of both the legislature by enacting such laws which will curtail the very fundamental right to life and personal liberty as provided under Article 21, so also by the executive, which is authorized under delegated legislation to make rules, regulations, or circulars, notifications, which are also considered as law under Article 13 of the Constitution, must not be arbitrary, and it must not violate or abridge or infringe the very fundamental rights provided under Article 19 and Article 21 of the Constitution. So also such fundamental rights as provided under Part 3 of the Constitution